Chief Justice, my ladies and my lords, I have 2 minutes, and I want to make the following point briefly, that the Constitution is not a mental construct. The Constitution is not an academic abstraction. The Constitution is the document the Kenyan people gave themselves to manage their affairs. And Madam Chief Justice and my ladies and my lords, in answer to the question the question of amendability or non-amendability, looking at Article 255, Subarticle 1, if you my Lord, my Chief Justice, I understand I've been given 5 minutes by the AG. I don't know whether they can confirm that to be the case. Yeah, I was beginning to think how I'll rush over this point, but I'm grateful. In his address earlier, which I wish to associate
Let's get that. You got the 5 minutes from the Senate. 5 minutes from the Senate.
From the Senate.
Yes.
I'm grateful. My Lord and my ladies, the two decisions by the High Court and the Court of Appeal was a case of usurpation of the sovereignty of the people and a judicial overreach. And I'll state the reasons why I say so. If you look at Article 255, subarticle of the Constitution, and I like the words that my learned friend Mr. Paul Mwangi used, and consider which are the sacrosanct provisions of the Constitution. My lords and my ladies, what is more sacrosanct than the supremacy of the Constitution? What is more sacrosanct than the sovereignty of the people? What is more sacrosanct than the Bill of Rights? And yet you find these provisions in Article 255 of the Constitution that makes those provisions amendable, so long as the procedural and constitutional processes under Article 255 to 256 and 257 are undertaken. There used to be an old philosopher in Britain called Samuel Johnson. There was a contest between subjective idealism and realism. And the idealists believed that reality was a mental construct. It was merely a perception. And Samuel Johnson convinced those with whom he was having an argument that if you want to prove that a stone exists, just kick it. Don't involve yourself in an argument whether the stone exists or not. So in this, the question that is before the court is as to whether the impugned provisions of the Constitution are amendable or not amendable. And my ladies and my lords, you'd find under Article 255, Subarticle 1, that even the most sacrosanct provisions of the Constitution are amendable so long as you determine which path you follow, whether it is by popular initiative or by parliamentary initiative. I am saying that it is a usurpation of the sovereignty of the people, because it means that any time the people would desire to amend the Constitution, that path will be through a minefield at the time of origination of the process to its conclusion. I think that power, the court should be very careful and exercise judicial restraint So that in terms of this constitution, which gave sovereignty to the people of Kenya, we do not, that power of the sovereign is not usurped by dint of judicial craft. Now, the other thing that we wanted to point out and is in our submissions, constitutions follow so many paths. If you look at the history of many constitutions, they have come through revolutions, they have come through military coups, they have come through an uprising of the people and so on. But the sovereign in Kenya, the sovereign, which is the people in Kenya, set out clearly that in whatever circumstances they desired to change any provisions of the Constitution, there was a process, a constitutional process, and a constitutional path to achieve that desired end. And therefore, any steps taken prematurely to interfere with the exercise of that sovereign authority, I think that would be a case of judicial overreach. And one would want to look at the history of Kenya, the process of constitution making, that we went through many paths, including the deliberations at Lancaster, including the amendments, including the constitution making process through a constituent assembly, as it were, the CKRC. And finally, when we came with this constitution, the path was that the proclamation of this constitution would be after the people themselves had made a decision through a process that involved the people at every time and instance. And therefore, it would be to rewrite the Constitution, to read into the Constitution what is not in the Constitution. And I think if we take that path, then we obviously will be creating tension. We're used to tensions between the executive and the other arms of government, like Parliament or the judiciary, but have a tension between the people and any arm of the government where the people are stopped either by legislation, which goes out of the constitutional remit, or by decisions that stop the people from exercising their right. I think that would be giving ideas to Kenyans to find out another path to reach their desired end in changing the Constitution that, as my learned friend Mr. Rara said at the beginning, by reading the preamble, I think the preamble to this Constitution is very important, that this Constitution is enacted by the people and the people have given this Constitution to themselves. And the powers exercised by all arms of government, including the judiciary, is a delegated authority. Therefore, we would urge the court to allow the two appeals by the Attorney General and the IEBC, and to dismiss the appeal by Mr. Morara Omoke. I thank you.
Thank you very much. There is one part